Assalamualaikum and greetings everybody. I am Amnie Syakirah Yosrini, matric number 049714 and from Bank 4A. And thank you to Najat on her explanations before on trust, which now I will be continuing on justice. Anyhow, I am sorry that the background isn't that interesting and hope that it won't cause you distress or distractions. Before we start, I would like you guys to sit back, relax, lie down if you have to, and give your full concentration on my presentation. First of all, before we get to the real talk of this topic of justice, I would like to share with you a fact about this woman you saw in my slide. I believe some of you knew her and some do not. So who is she? She is called Lady Justice. Lady Justice originates from the personification of justice in ancient Roman art and is equivalent to the Greek goddess. She symbolizes fair and equal administration of the law without corruption, favor, greed, or prejudice. I will explain briefly four per item that she holds. The scales represent the weighing of evidence. The blindfold represents impartiality, which it is the ideal that justice should be applied without regard to wealth, power, or other status. The sword represented authority in ancient times and conveys the idea that justice can be swift and final. And finally, the garment that she wears symbolizes the status of the philosophical attitude that embodies justice. The reason on why I'm telling you about Lady Justice is proportional to our topic today, which is justice, and so that you could use this Lady Justice into your future assignment. Now let's get started on our real topic. Just a quick note, most of the information I'll be sharing today is taken from this book, Essentials of Negotiation, which I believe lots of you read this beforehand before we start our first lecture this semester. Okay, now what is justice? Justice is just behavior or treatment, but as I searched on the internet on Cambridge English Dictionary, it is defined as the condition of being morally correct or fair. In the book of Essentials of Negotiations, page 213, it mentions that justice has been a major issue in the organizational sciences. Individuals in organizations often debate whether their pay is fair, whether they are being fairly treated, or whether the organization might be treating the group of people in an unfair manner. Meaning here, this issue of justice or being fair has been debated long since, which it often happens in various of corporations. There are four parts of justice: distributive justice, procedural justice, interactional justice, and systematic justice. In case you're having a hard time in memorizing all of these forms, I have simplified it as DIPS, D-I-P-S. And so DIPS stands for D for distributive, I is for interactional, P for procedural, and S is for systematic justice. Just remember this photo, then you will recall these forms of justice. We will first start with distributive justice. By the way, you can read all of these forms of justice in the book, page 214. So, distributive justice is about the distribution of outcomes. Parties that involve are concerned with the socially just allocation of resources, which the concerns are: 1. One party is receiving more than he or she deserves, that 2. Outcomes should be distributed equally, or that 3. Outcomes should be distributed based on needs. And so the three questions that involving with distributive justice are: 1. What goods? 2. Who got them? And 3. Why? For example, one study showed that outcome fairness is often determined in a distributive negotiation as the point midway between the opening positions of the two parties. Meaning here, an equitable end result must be present not in the end of the negotiation but in the opening positions where both parties make their demands before starting their settlement. The presence of such an obvious settlement point appears to increase both concession making and the likelihood of settlement. Equal distribution is thought to give the parties involved a sense of full-fledged membership. Lastly, distribution according to need ensures that everyone's basic and essential needs are met by the end of the settlement. Or if one people have sense that they are at unfair disadvantage relative to others, or that they have not received their fair share, they may wish to challenge the system that has given rise to this state of affairs. Moving on, the second form of justice is procedural justice, where it is the process of determining outcomes. Procedural justice is the idea of fairness in the processes that resolve disputes and allocate resources. One aspect of procedural justice is related to discussions in the administration of justice and legal proceedings. Parties may be concerned that they were not treated fairly during the negotiation, that they were not given a chance to offer their point of view or side of the story, or that they were not treated with respect. As we all know, a negotiation is an environment in which parties are offered an opportunity to shape the outcome that they want to receive, so procedural fairness is generally high in most negotiations. But in this term of justice in a negotiation, the concerns about procedural fairness are more likely to arise when negotiators are judging the behavior of third parties, which is negotiators viewing the third party as neutral, seeing that party as trustworthy, accepting the third party's decisions, which means they voluntarily accepting the party's decisions and directives. Individuals' perceptions of pseudo-religious encounters are based on four central features of their interactions in negotiating, which are, and this image I have been included in my slide, so you guys can go and read it there because I think you can see it clearly here. So first one is whether they were treated with dignity and respect. Second, whether they were given voice. Third, whether the decision maker was neutral and transparent. And four, whether the decision maker conveyed trustworthy motives. The third form of justice is interactional justice. Interactional justice is about how parties treat each other in one-to-one relationship. It is defined by sociologist John R. Schermerhorn as the degree to which the people affected by decision are treated by dignity and respect, while Susanna Baldwin defined it as the quality of interpersonal treatment received by those working in an organization, particularly as a part of formal decision-making processes. Research has shown that people have strong expectations about the ways another party should treat them, and when those standards are violated, parties feel unfairly treated. It is fostered when decision makers treat people with respect and sensitivity and explain the rationale for decisions truly. And there are four keys of aspects of interactional justice, which are truthfulness, respect, propriety, and justification. When the other party practices deception, is not candid and forthcoming, acts rudely, asks improper questions, make prejudicial and discriminatory statements, or make decisions or takes precipitous actions without justification, negotiators feel that fairness standards have been violated. The final form of justice is systemic justice. It is the norms that develop on how an organization should be treating a group of individuals. When some groups are discriminated against, defranchised, or systematically given poor salaries or working conditions, the parties may be less concerned about specific procedural elements and more concerned that the overall system may be biased or discriminatory in its treatment of certain groups and their concerns. An example that I could think of is when a manager asked his or her employees to work overtime in finishing the workload of the day. However, it is against the policy where it is written in Malaysia Employment Act 1955 that employees can only work not more than 8 hours per day and the rest will be considered as overtime and they should be paid. If then this term isn't obeyed by employer, the employees will not be productive workers in serving to the performances of the organizations. This is due to the employees being disfranchised by the employer. The same concept is applied in a negotiation. If a party isn't being as fair in their demands to the other ones in making a fair settlement, the other party may feel as if they being discriminated. They won't be as cooperative in coming out with an unbiased settlement. To conclude my presentation, I believe that negotiated exchanges might be seen as procedurally fair in the earlier, but then after such agreements are struck, negotiators might perceive their partners as less fair. Next, negotiators who are encouraged to think about fairness are more cooperative in distributive negotiations. And finally, Involvement in the process of helping to shape a negotiation strategies increases commitment to this strategy and willingness to pursue it. So I think this is all about justice, and I think I now will be continuing on with the last part of our presentation. Thank you for sticking out with me, and hope you will not have any problem in understanding our topic today. If there may be any confusion from all of you, hit us up with question later by the end of the presentations.